Good morning or good afternoon, depending on where you are. My name is Dan Uhrman. I'm a SCORE mentor. I'm here with Michael Steele, who's an expert in the legal matters that he'll be presenting today. I'm going to give you a brief little commercial about SCORE and what they are. So I'm going to share my screen. Everybody can see the slides there? Mike, can you see the slides?
Yes.
Okay, good. All right. So basically, SCORE is the largest network of free volunteer small business mentors in the nation. And no matter what stage your business is in, let's see if I can get that to go. There we go. We are available to provide a mentor. We empower all entrepreneurs to succeed. We have created over 54 nationally, over 54,000 businesses, 61,000 jobs, and there are over 58,000 clients. We have a code of ethics. SCORE members are not permitted to make any money in any way from SCORE clients. And volunteers cannot use client or member database for commercial reasons, and all client information is confidential. We have a success story to tell you every day of the week. Here's one of them. Our business is supported by the Small Business Administration. They do provide us with a relatively small grant, so it's not like we're highly dependent on them. We run on volunteer energy, and we also raise money locally for the majority of our operations. And that is my presentation. And with that, I'm going to stop my video and turn it over to Mike.
Hi, everybody. Thanks for the introduction, Dan. I'm going to start sharing my screen. Should be seamless. And just confirming, Dan, that you can see my screen, correct?
I can see your screen 5 by 5.
Perfect. Perfect. Okay, so as Dan indicated, I'm a subject matter expert for SCORE, and my specialization is intellectual property, and I am personally a patent attorney. SCORE is a great organization for me. I help a lot of the entrepreneurs with questions about IP, and as was indicated by some of the SCORE ethics, I don't offer legal advice, but I do offer education, and that's what this is, considered here. So if you actually have an issue that needs to be addressed, I can refer you to one of the people in my network that can, handle some of the more low-level stuff. But I'll do my best to answer any questions and get you pointed in the right direction. So today's presentation is covering the major types of intellectual property. And what it shows, what it means to be infringing those types of property. I think that's often the best way to understand each type. So here's just the agenda. We'll leave some time for questions and go through a number of examples today. Here's a bit of background about me. I've been a patent attorney for 20 years. I won't go on about this because I assume all of you can read, but I've done preparation and prosecution of patents, so taking the disclosures from the design phase all the way through the dealing with the maze of the Patent and Trademark Office and turning them into issued patents. And I've done several thousand patent applications throughout the world, where I've worked on them directly or indirectly. The first question that I often face is, why do you need intellectual property? Why is that even a concern? And one of the best examples that I can give is from the movie The Dread Pirate, or the movie Princess Bride, when they had the Dread Pirate Roberts, and he was explaining to Princess Buttercup that he actually wasn't the quote-unquote real Dread Pirate Roberts, but he had inherited the name. Basically, he had the name, the logo, all the things that you normally associate with any type of brand. And as he put it, no one would surrender to the dread pirate Wesley. The only thing I think that he got wrong is that in the movie, he said he wasn't the real dread pirate Roberts. Well, in intellectual property world, effectively he was, because the quote unquote dread pirate Roberts had become a brand, and he had either purchased or otherwise been given the brand, and he was able to use that to his advantage. Obviously, he was engaged in illegal conduct, and all of you are engaged in lawful conduct, but it's really largely the same concept. So there are four major types of intellectual property. You have trademarks, which are like slogans, logos, things like that. Copyright, which is original works, though could be books, sound recordings, productions, um, pictures, things like that. Trade secrets, which sort of implies, an invention that you don't disclose how to make and use, but you're able to get the benefit of it. The famous ones being the KFC recipe and the Cokes and this recipe for Coke. So we'll talk about those briefly, but there's not a whole lot for that today. And then patents, which is my space, my specialization, and that is taking what could be a trade secret, describing how to implement an invention in a patent application, and then claiming it. And basically, the deal with the government is if you show the people how to make and use that technology for 20 years, you get a monopoly on being able to exclude others from making and using that invention. So we'll start out here by, you see a bunch of different symbols on products that you buy. And before I went to law school, I didn't even know what some of these meant. So I thought it'd be good to show you. So you have the service of the TM is a what they call a common law trademark. It means it's not registered. A Circle R means you have a federally registered trademark that you requested from the U.S. Patent and Trademark Office. A service mark is the same as the trademark, the common law trademark, and then the Circle C is copyright. Circle P means a sound recording copyright, so a song or something like that. And I saw Circle U on a bottle of A1 sauce one time, and I didn't know what that even meant. Apparently, that means kosher, so a certification of kosher. Not actually an IP right, but I thought that was a interesting side note because it looks so much like the other IP symbols. So we'll start talking about trademarks. Trademarks are slogans, logos, or trade dress. Trademarks develop from the strength develops from the use of the trademark and how well known they are, not from the filing. A lot of people think, well, I filed a trademark and now it's rock solid, and it's not really that way. It's how well the trademark is known to people, much more than it is going to be about the filing. The filing is more of giving the world notice that it exists, but the reality is the strength of a trademark, it comes from its continued use. Trademarks are used to provide a legal recourse for somebody that is making a confusing, trying to imply that they are affiliated with a company, to avoid ripoff products, and they allow you to establish goodwill with your customer base, and they're a good communication tool because people see the particular logo that you're using, and they know that that they can trust your brand. It's important to understand that the very purpose of trademarks is not to protect the companies, but to protect the consumers. Because what will happen is you have large companies like Apple, and then some company will make a product that looks very similar to that and uses a logo that might be very similar but not quite the same, and then some customer thinks, oh, they're clearly it's clearly an Apple product, or it's Apple licensed, and the customer deserves to be able to discern which is an authentic product and which is not, and that's the fundamental reason that we have trademark. So one of the questions that I get a lot is, should I register my trademark, or must I register my trademark? And the answer is, uh, you don't have to, but you do get advantages over a non-registered trademark. Um, you can basically, if you were to assert your trademark by suing somebody, you would get higher damages, and you have a presumption of validity that's like the evidentiary standard in such a proceeding would be lower. So when to file a trademark versus when to rely on a common law trademark, which is free, would be the situation where um, you're allowing a third party to use your trademark in some capacity. If you're using it for advertising of an event, if they're printing them on their business cards as a certification or something like that, and you're not controlling the use of the trademark, then it's usually a good time to file one. I find that you can typically file and prosecute a trademark for as low as about $1,000 if it's a very straightforward one. Is kind of like, I would say, the going rate. And in and for a startup, if you don't have that capital initially, a good solution is to assert the common law trademark, and all you have to do that is put the superscript TM on your product and use it anytime that you use your product or your logo. Always put it there, because it's telling the rest of the world that this isn't just a generic name of a product. This is my trademark. And you can use that then as evidence of usage when and if you file the trademark, register the trademark later, and then you switch it to the Circle R when you use it. And that's kind of like when you cross that boundary, when you allow anyone else to use it, or obviously if you're making enough money that the cost of registering isn't a huge percentage of your income or anything like that. So it's just some general guidelines. So what is trademark infringement? It means that there's a substantial likelihood of confusion. Um, Basically, that if the average consumer of a particular product would consider the two companies to be affiliated, then that's usually considered substantial likelihood of confusion. And so I'm going to go with, as an example, a real world example of a case where you had LexisNexis, and which they have two databases. Lexis is the legal database that they created, versus Toyota, that was creating Lexus, the brand for the car. Obviously, the names are very similar, but the product line is very different. And as you can see, there was factors looking at the how to determine if there's a substantially likelihood of confusion, where we have the similarity of the marks, the similarity of the products, the sophistication of the consumers, the predatory intent, renown of the senior mark, renown of the junior mark. In this particular instance, the court leaned on number 3, sophistication of the consumers. What they said was Lexus, who was the senior mark, their customer base were attorneys, and they were going to be less likely to be confused about Lexus, the database, and Lexus, the car, than your average consumer, that they were a well-informed group. Whereas I think if this had been a more well-known brand, this is extremely well-known in the legal community, but if it had been a well-known brand that everyone used products from instead of just a very specific subset, I think that the court would have held that there was infringement. In this case, the court held that these did not infringe. So that's a example where you have not infringement for a specific reason. So let's go through another example of trade dress. One of the more complicated issues in trademark law is the idea that the look and feel of your product is actually covered by your trademark. And restaurants will sometimes assert these claims, saying that one restaurant is a clear, ripoff of another one. And this case, 2 Pesos Taco versus Taco Cabana from 1992, went all the way to the Supreme Court, and they found that there was trademark infringement of the trade dress, because basically the the two restaurants looked extremely similar, and it turned out, as often the case is in trademarks, that the Two Pesos Taco was previously affiliated with Taco Cabana. I believe they switched from being a franchise, or got out of franchise negotiation, just decided to copy them instead of paying them franchise fee. But the two restaurants, looked very similar, and they had like the same food, the same menu, and all of that. So the court said that there was trademark infringement in that case. So a little bit closer to my home in Ohio, Northeast Ohio, we have similar situation where we have Barrio Taco, Barrio Brothers versus Condados Tacos, which is the company's Revolution or something. And anyway, what if you looked at the two restaurants? I remember the first time I went into a Condados Taco, I knew there was some sort of connection. And apparently, originally, the Condados Taco was an original partner of Barrio, and then they broke off and started their own restaurant. But it has a very similar situation where you are ordering tacos with a notepad, telling them what you want. They both use like Day of the Dead type of decor. But what the court said, that it wasn't that the two restaurants weren't similar, but there was some differences, particularly in the coloring, as you can see in this. Like, one's pastel and one is like black and white. But they said that Barrio Taco hadn't done enough to actually establish a trade dress, because they were using too many generic elements, like all the Day of the Dead designs that they had. Those are so common for not just restaurant theming, but for anything that's often bringing up a Mexican theme, that they just said it would preclude too much. And a lot of the stuff that they were arguing was part of their trade dress was extremely common and non-functional elements: foil wrapped food, mason jars for alcohol, and the order forms. None of those were unique, so there was just a lack of uniqueness. This was a very close case, in my opinion, just because if you'd ever been to either one of those restaurants, the other one would remind you. However, I think really the difference is, one would remind you of the other, but there wouldn't really be any doubt that you were at a different restaurant. I think was the real test here. They made it just different enough that it was clear to not be the same thing. Another thing I'm going to spend just a minute or two on is genericized trademarks, just because they're kind of a fun subject in intellectual property. Anybody that's ever used a thermos probably is familiar with the story that King Sealy used to own the trademark of it, but then the name went from like vacuum bottle to just everybody calling him a thermos. And eventually the court said this is just an English word, right? And so you can't protect it anymore. They lost their trademark, but they still were allowed to use like the term original thermos and capitalized T. Everybody else has to use the lowercase t because it's just a noun, and they're the only ones can emphasize that they were the creators of the thermos. So interestingly enough, there's a number of genericized trademarks, and I just listed them here. You have dry ice, escalator, flip phone, a number of them that I had no idea were originally trademarks. And then kind of famously this last year, Taco Tuesday was genericized and brought to the public domain. The one that I say is certainly possible in the future is the concept of the blizzard. Basically, if you go to any soft serve ice cream place, they'll have an item that they call they got the McFlurry, the Whiteout, the Wizard. All of these are implying they're a blizzard, and if you ask them what they're like, they'll almost always say, "Oh, that's like a blizzard," and everybody knows what that is. Somebody once, and I don't know what the word would be otherwise. Somebody once suggested that the term concrete mixer was used, but I looked that up, and that's for frozen custard and then candy added. And as an ice cream lover and a overweight person, I can assure you I would never confuse ice cream for frozen custard, and I'd be very disappointed if I had ordered something that I was expecting to be ice cream and I got the the frozen custard version. So I don't think that those two words are exactly the same, but that's just my opinion. So let's talk about copyright next. Copyright, as I mentioned earlier, covers original works, computer code, sound recordings, performances, concerts, things like that. One of the things with copyright is you don't have to register a copyright until you want to enforce the copyright. The big thing is keeping good documentation that you maintain the copyright. Now you can register them, but it's just they're a pain. And the more that you have to get into like a system of doing it, and you register with the Copyright Office. But in general, you create the copyright when you can put it into a fixed medium. And then if you want to sue somebody asserting the copyright, you can go file it. You can file the copyright right then and then assert it. And that's otherwise the Copyright Office would be bombarded with so much stuff that they would not be able to keep up. The fair use doctrine. The fair use doctrine is a very complicated subject, and everybody seems to know that it exists. But the fundamental idea is that you're allowed to refer to something as its name, as long as you don't diminish the copyright owners to make money from their work. And so a very, very common example of this is, I'm allowed to refer to the Cleveland Browns or the Cincinnati Bengals without paying the NFL any type of fee or anything like that, because that's considered fair use. If I'm talking about statistics or something from the game, that does not diminish their work. And I'm not, and I'm no way implying that, I own those type of things. There also is another fair use exception where a parody. So if it's a parody, then like, a comedy sketch or something like that, then you pretty much have a very strong argument that it would fall under the fair use doctrine, basically partially for claim to freedom of speech. So why do you need to register? As I mentioned, if you're going to bring a lawsuit, you do need to register. And another thing is understanding employee created works. Employee created works are considered to have been authorized by the employer for copyright purposes. But I do want to emphasize, this does not apply to work for hire. Work for hire being situations where you have a contractor that's not your employee to do something that, if you go to a tattoo parlor, for instance, and you get a tattoo on your arm, that does not give you the copyright to that tattoo. The tattoo artist still owns the copyright. And so in those cases, you're allowed to, take pictures of your arm and show it on Facebook or whatever. But what you wouldn't be allowed to do is go making putting that tattoo on somebody else. Now, obviously, the person would have to bring a copyright claim against you to stop you from doing that. But it's just important to understand, the difference between hiring somebody to do work to a particular job for you and having your employee. When you have an employer-employee relationship doing something, the copyright rules are different. So let me give you some examples of copyright infringement. A couple of famous cases. We have Kerr versus New Yorker magazine. And so on the left was the original picture, and then the right was the New Yorker. And Kerr, the artist of the one on the left, sued the New Yorker for copyright infringement, saying there was substantial similarity. And basically, they agreed that it was inspired. The one on the right was inspired by the one on the left, but that they were providing different messages. The one on the left is more edgy and aggressive. The one on the right is more serene and is creating more of a relaxing view of New York City, and the other one is more implying that it's like sort of a dangerous place. And as a result, they said that there was an infringement. The factors that go into copyright infringement is you look at the uniqueness, the complexity of the original work, unexpected elements that are repeated in the copied work. Sometimes, and one of my favorites is the appearance of the same errors or mistakes in both works. Comes into situations in computer code. If you have typos in the comments section, the commenting of the code, that's often damning evidence. Another one is they made a movie called Paper Towns, which is a real issue with when cartography was much more popular as an art form, and cartographers would put fake towns into their maps. And in those situations, if somebody copied their map and they put the fake town in, they knew the original work had been copied because the town didn't exist in anyone's name but their own mind. And there was a similar case there where there wasn't copyright infringement, where a phone book was copied, and they had put fake phone numbers in there. But interestingly enough, they said that phone books weren't copyrightable because they didn't have an artistic element to them, since they were just putting the names in alphabetical order. And then there's the obvious attempts, crude attempts to make the appearance of dissimilarity. I don't have any real world examples for that, but some great fictional ones that would be considered fair use because they were parodies are McDowell's from Coming to America and the Buy More from the TV show Chuck, or Chachi's from, I think, the movie Office Space, whether they're just obvious to be implying that they're with a particular company. But if you created those in the real world, those would easily be infringing on those copyrights. So here's another case where we did have infringement, and the New Yorker created this image showing, I think it was the New Yorker's world view of the world from 9th Avenue was the name of the art piece on the left. And what it was trying to show was this concept that New Yorkers, everything in the city was so important to them. Everything is very detailed, but as soon as you go over the Hudson River, they just think of, you got Jersey, the middle of nowhere. Then you have the Pacific Ocean. Basically, their entire world is focused on New York City. And anybody that has known a lifelong New Yorker like I have, that's a fairly common trait that they have. They don't, if it's outside of the river, past the river, they don't always consider it important. So that was, I think, in 1978 when this was made, and then this movie, I believe, was released in 85 or 86, Moscow on the Hudson, and they had this as the movie poster. And the court looked at them, and they were clearly, and the artist for the movie poster admitted that the one on the left was the inspiration. And importantly, they were conveying the same message, even though they were looking over the Atlantic Ocean from the other direction. It was like the same idea that you had, New York emphasized. And then, interestingly enough, the defendants tried to argue, well, it was a parody. And the thing that the court said, well, it wasn't a parody of the original work. It might be a parody in general, just as the original work was a parody of how New Yorkers might view the world. It wasn't a parody of that. It was more consistent with the parody that the original one was conveying. So they said it was similar enough that it was considered a derivative work, and therefore was infringing the copyright. Is an interesting case. So another case that happened that is a little bit less famous, but everyone has ever used a zip file from this. PKZip was the company that originally made the zip file, and they were started in the 1980s. it was Phil Katz was the programmer of PKZip and giving the name PKZip, and he originally worked for a company called C that made this .arc compression. Um, and as I mentioned earlier about misspellings, at court, they were able to prove that PKArc, which was their first product, was released, had copied the code from C because they had the same comments, including misspellings in the code, and therefore they were also deemed to be a derivative work and therefore an infringing product. And as a result, interestingly enough, as part of the settlement, PKWare developed their own algorithm, the .zip algorithm, which is still used today. So that's the origin story of how zip files were created. So the next one, and I'll go through this as quick as I can because it's relatively complicated and not always important to all the listeners here, is understanding what an API is. So an API, for understanding this fair use situation. So an API stands for Application Programming Interface. And what that is when you create a software application, a lot of times you'll create an API that effectively is a remote control for the API. And so another program can be created that can interface with that program through the API. It's a very common thing to do with apps on a phone. And basically you can look at it as you have a user using their phone, and their phone then provides a request to the API, as we see here, which can be abstracted to a waiter. The waiter then goes into the kitchen, gets the information, which is analogous to the food, and then returns it to the user. And so from the perspective of the user, they don't really see what's going on in the back end. They only see this, on their front phone, but there's a lot going on behind the scenes. So why is that important? So this is an example of a Twilio API where you had a text message sent through a mobile app, for instance, without using, the traditional mobile app mechanism. So there was a case in 2021, Google v. Oracle. This was a landmark fair use case where basically Google was using Oracle's, who were originally Sun and Oracle bought them. They were using Java, their own version of Java, to write Android. And in this case, what they did was they used the same function calls, the same APIs that were used in Java, but they reprogrammed all the backend information so they were trying to avoid the copyright infringement. So even though it used exactly the same code for the function calls, the underlying code that was executing those function calls was different. And the court said that they didn't use enough of the original Java code, and that Google copied those lines not because of their creativity, their beauty, or even in a sense because of their purpose. It copied them because programmers had already learned to work with Java, and it would have been difficult to attract programmers to Android without them. I don't disagree with that statement, but I will always disagree with the finding from the court. I would have, if I had been on the Supreme Court, I would have had the same reasoning, and that's why I would have found for infringement, because basically this allowed Google to hire Java programmers, but they were not using Java. They just looked like they were using Java, and so it really allowed Google to get the benefits of Java without paying Oracle a license. Because there's so many good Java programmers, Google would have had to create their own ecosystem with their own programmers, and I felt like that was a free ride that Google got. So I don't agree with the judges here, but I am not on the Supreme Court, and so this is the law, and that's what it is. And so basically, when I see situations where people are trying to rely on copyright law for protecting computer code, I always bring up this case because I can show you how far-reaching the fair use doctrine can be for potential infringers to get out, escape liability by using the fair use doctrine. So we'll talk about, as I mentioned earlier, just trade secret real fast. Trade secrets are information that has an economic value that's not generally known and cannot be legitimately obtained, and that you are making reasonable efforts to maintain the secrecy. You know, in the case of KFC, you can see right there, there's a picture of the vault, where it's in a random hallway, probably not so random. And supposedly there's only like 5 or 6 people that know the recipe, and they actually have 3 factories that make the recipe for the flour. They have one that makes half of it, half of the recipe, another that makes the other half of the recipe, and then a third company actually mixes the two together. So no one factory has the full recipe. And this one can be more difficult to prove than other types of IP, because reverse engineering is a defense to it. Because if you can show that as a third party, you were able to just look at the product and be able to reverse engineer it. The other problem is, even if you're able to show that you had been ripped off on your trade secret, if the other company publishes it on the internet, yeah, you can go after the company that published the trade secret on the internet, but then other third parties are allowed to use it, and you cannot go after them. So you can only go after the original infringer of the trade secret. It's sort of a limitation on the law. Trade secret is still relevant because it's often used for like gene sequencing, and a lot of drug companies, especially before they file patents, they have a lot of procedures to keep everything confidential. So let's get to the last part and still have some time for questions. Patents, my specialty. There are 2 main types of patents. There's utility patents and design patents. But there's actually a third type that's much less common, called plant patents. And I had never actually encountered a plant patent until I was actually asked to advise somebody on SCORE about them, because they were dealing with a plant patent. So that, you know, they're still very relevant. It's just that they're much less common. And you know, but by far the most common 2 types are utility and design. Utility focuses on what the product does. Design focuses on what the product looks like. A lot of times the same product will have both. And here's just some, you know, different patents over the years. We have the design patent for the Simon Says game, and then on the left we have it was actually a utility patent for the game of Monopoly, and I think that's Mr. Potato Head on the second to the left. Interestingly enough, the design patent for the game of Simon, even though it had expired, was probably more useful than a utility patent could have been, because when my kids were old enough, I mean, the Simon when I was a kid had actual buttons. And when my kids got a Simon, you know, 30 some years later, they were touch sensitive. So they're actually just pieces of touch sensitive glass. In that case, the utility patent wouldn't have been infringed, but the design was the same. So the design patent would have been infringed if it was still enforceable, but it had long since expired. So one of the things to understand with patent infringement, with utility patents in particular, is understanding what infringement looks like, or how that's determined. Each utility patent has at least one claim, and that claim will have these elements in it. And the claim will typically be written, you know, a device comprising element A, B, and C. What the court is saying, or what the infringement works, is you have to have an infringing device has to have A, B, and C. If they have A, B, and C plus a million other things, they'd still infringe. But if they don't have A, B, or C, if they don't have all 3 elements, they do not infringe. So as the example here, we have element A, B, and C. And then let's say claim 2 has and element D. An infringing device that would had infringed claims 1 and 2 would be elements A, B, C, and D. One that infringed only claim 1 would have A, B, C, not have D, in this case, E, F, and G. That would not infringe. A non-infringing device, period, would have B and C, and it doesn't have A. So A is part of every claim, like all the independents and all the dependents. So that's how the line is determined between infringement and non-infringement, is you have to have all of the elements of the claim. So a real world example, any woodworker is familiar with saw stop. Saw stop is a technology where you have a spinning blade, and the blade, when it's turned on, if you touch the blade within milliseconds, the blade will fall below the table and hit this brake here. In the interest of time, we won't go through the videos, but yeah, you can check it out online. Just search for saw stop for anyone that's not familiar. The Bosch system was very similar, but it didn't hit a brake. It used their airbag technology, and just made a small explosion, and the spinning blade fell beneath the table and didn't hit a brake. It just kept spinning, but since it was beneath the table, it wouldn't cut your finger. And it both have happened in milliseconds. That's important. So Bosch started importing this saw, and then Saw Stop, which was founded by Steve Gass, a patent attorney, sued Bosch. And one of the things when I was, because as a woodworker, I saw this a lot. People would say woods are completely different, and they are different, but that's not the standard. You have to look at the patent. What the products have doesn't mean that they're infringing or not. You have to look at what the patent has.
Okay.
I'm gonna fast forward here. So in this case, SawStop had this particular patent, and one of the elements was they had a reaction system associated with the detection system and the cutting tool, where the action system configured to retract the tool below the work surface within approximately 14 milliseconds. They don't tell you exactly how that retraction happens. They just specify a time period for it to happen. And then, so the Bosch device had all of these elements, and they did infringe. Interestingly enough, in the International Trade Commission case, the Bosch asserted a second patent, and they did not infringe on, because they included the element a brake configured to engage and stop the blade. As I mentioned, there was no brake in the Bosch patent. Instead, it created that small explosion and dropped beneath the table. As a result, in one case, one patent they did infringe, and one patent they didn't infringe. The key here is you only need to infringe one patent. Bosch's liability didn't increase because they infringed two patents. In this case, they infringed one, which is enough to bring. In this case, they were able to block the importation of that product. The last thing that I'll talk about before we open it up to some questions is NDAs, just because the last I got an email about asking them to add this. I didn't really know where it would go in the rest of the slide, so I just put it here at the end. So a lot of you are aware NDA stands for non-disclosure agreement. You typically, when you're inventing something, or you have a trade secret, you have people sign an NDA. An NDA is not intellectual property. It's a contract that defines rights related to intellectual property. The NDA itself should explain what the remedy for a breach of confidentiality is, and sometimes they will explain how that confidentiality is to be made. it's important that an NDA is not a replacement for intellectual property. You know, if you have an invention and you know, you don't go through with ever patenting it. It's just, well, I don't need to. I have all these NDAs that eventually the court can actually determine that you have concealment of an invention where you aren't putting it out in the real world, and you know, and you had NDAs, you're not really utilizing it. So somebody else came and tried to patent it. You know, they would be able to, and also if you tried to go and patent it and they saw all this information, sometimes they can determine. That's a very rare case, very rare. But it's just an emphasis that, you know, an NDA is not, you know, not a part of IP. And then one of the most important things is if anybody asks you to sign an NDA, make sure that you know why you're signing it. You know, understand, you know, what you're looking at, and just as importantly, find out when the NDA expires. Very common that an NDA would expire once a patent application is filed for an invention. So any trade secrets or something like that, you'd obviously want to include those in a patent application. And at that point, there's no value to the NDA anymore. So before you sign an NDA for your employer or anyone else, make sure you understand what are the situations, what are the consequences for breaching it, and how does your burden ever expire on it. And there's been a number of times where, I mean, typically I won't sign NDA for inventors, and I've been asked to sign an NDA for several times, and I'm like, well, there's nothing in it for me, you know, like, you know, in this case. So, you know, why would I do that? But people will ask you to regardless. So, you know, don't sign away your rights. There's some problems with NDAs I've seen, in particular when it comes to patent applications related to software. A lot of times when contractors, they get an NDA signed, and then the company that hired like the programmers to write something, they think that the NDA entitles them to the intellectual property of the program, and it doesn't. It allows you to use the program, but it doesn't allow you to file a patent on the program, because the programmers of the contractor might be inventors. They may or may not be. Yeah, that's another determination. But what you really want to make sure of is that when you are hiring programmers to write something for you, that it's clear who owns the intellectual property. Because that way, even if the programmers are inventors, they have an obligation to assign it to the original company that hired them. And so they would still be able to own the patent on the resulting product, regardless of who invented it, because ultimately, inventorship is a very separate question from, you know, who owns the IP. These are two different issues, and they're not. And an NDA won't save you there. You can't have an NDA stating that the one company is the inventor, because the inventor is a matter of fact and law. You know, but what you can do is have the contract specify not only an NDA, but the company hired has an obligation to assign the invention to the parent company. So there, or the hiring company. So that's what I've got, and we still have some time for some questions. So I know that's drinking from a fire hose, and each one of those topics could be a whole hour in itself. I'm gonna try to give you the 10,000-foot view. So I'll open it to some questions now.
Mike, can you see the chat?
Let me end the slideshow, and I will stop my share. I cannot see the chat. Okay.
Okay,
So
I'll
now
read it to you. I'll read the chat
Okay.
to you. This is from a attendee says, can a utility patent apply to a business app?
That's a, forget $10,000 question. That's $1 million question. Each case is very, very hard to answer at that. To get a pure economic benefit, the answer is no. But what you have to be able to show is that there's a technical improvement that comes from the software application, not just an economic one. And if you can show that there's a technical benefit, and how you would do that is showing, you know, that the computer, for instance, as an easy one is the computer will work faster by running that. Even if the benefit is like advertising or something like that, then the answer is usually yes. But that is a massive issue in patent law, and I could be talking for 10 hours on that subject, and no one would have a clear understanding of it. It's just a matter of what is considered business method or economic and what's considered technical is really what it would come down to.
Now, another question, it's a little complex. Um, the gentleman inherited art collection, 500 pieces of art. And he wants to know, he doesn't know if the art is original or not. And he wants to know what his copyright status, I guess, is on the art that he's inherited from his father, not knowing the providence of it.
Okay. So and that's a good question. So I'll just answer it in generalities here, is that when you buy art, you do not buy the copyright of the art. It goes back to what I was talking about, work for hire, where you hire somebody else to do something for you. Now you can take pictures of it and like show it, on the internet to sell it and things like that. But what you can't do is like start reproducing it and selling it, as long as the copyright remains in force. I believe the copyright term is life plus 70. So if it's more than 70 years after the original artist died, then there is no copyright, period. No one has a copyright. And then you would be able to, make reproductions of it. But anybody else could too. They're part of the public domain. If you want to make reproductions of it, you have to get the license from the original artist. It really doesn't matter there if they're original works or not, because even if they're copies or of original works, then that second artist was actually an infringer of the copyright. But again, I don't know in this instance if any of these people are even still alive or what the time frame is. So that's kind of a lot of the questions there. But in general, if you buy art off somebody or it's transferred to you, you don't have the copyright to it. You just have the right to the work, and for your enjoyment or to sell it, that particular piece. That's usually the rights that you have.
Okay, I just want to remind everybody, you will get a copy of the slides. Mr. Steele's contact information is in one of the slides. Is that correct, Mike? You have your.
I honestly can't remember. My email address for SCORE is michael.steele@scorevolunteer.org.
Okay, here's a question. I have a utility and design patents on apparel. Are these rare? What is the best way to get them licensed?
I would say the utility patent on apparel is rare, but I've seen it in situations where you're going to have tech gear. So if it's like, for holding AirPods or something like that in a specific way, those tend to be the utility patents. Very common to have design patents on apparel. Just like you would also typically have logos on apparel. So they aren't rare. What is the best way to get them licensed would be to find somebody willing to pay for them. I mean, in the sense of, if you want them licensed, you have to find a buyer. Now, the best way, honestly, is to start selling them yourself. Start producing like T-shirts or whatever and then you will have companies that can come and connect with you. I don't know the textile industry to know how buyers and sellers are found in that world beyond that. I am connected with a couple of IP licensors, but it doesn't sound to me like you have a licensee yet. You sort of need to have an idea of who would be buying it and who would be willing to pay for it before you can get to that stage.
Okay, one more question here. Is it advisable to file for an extension regarding a provisional patent if you are approaching the 1-year mark of patent pending status, if you are still raising seed capital in order to develop a working prototype of your electronic product for submission review as a new product offering?
The answer is definitely no, because there is no such thing. There are no extensions of provisional patents. They are an absolute an absolute bar. If you file a provisional application, you have 1 year to file the non-provisional application. However, what I would tell them is that if at the end of 1 year you are not ready to file a non-provisional application, you can file a second provisional application. You lose the date of the original filing one, but you could file a second one, which is still a relatively cheap solution, and then file after 2 years. But there's no way to file an extension for the provisionals. I honestly don't often recommend provisionals applications for that reason, or one of those reasons. I typically tell companies to get to a design that's ready for a non-provisional application before proceeding. But the problem is the non-provisional is much more expensive. And so it always seems like a good idea to try to save money up front, but then you run into the problems that you're seeing now. Is after a year, you still don't know about the marketability and the final design. So that's how that would be.
One more quick question. Is Google search the most effective way to perform a patent search on a product?
It's the cheapest way, and it's a good way. But the most effective way is to hire a commercial patent searcher and have them search it. They will do a much more in-depth. Part of the problem that you'll have if you do a Google search is all of the databases in various languages and things like that, trying to find foreign references. If you need a really rock solid way, there are entire companies that focus on patent searching, and they are the best. But as you can imagine, for anything, the best is never the cheapest. Google is really cost effective and pretty good for what they provide for free.
Okay, we're going to wrap it up here. It's the top of the hour. Michael Steele, thank you very much. Mike, if you want to repeat your score, email address, there's another question or two in the chat, but we really don't have time to tackle them.
Okay. Yeah, it's michael.steele@scorevolunteer.org. But remember, my name doesn't have an E on the end, so it's michael.steel@scorevolunteer.org. And you can reach out to me if you have any questions.
Thank you very much. Thank you everyone for attending, and have a good day.